Pranali, you can start.
A pleasant good morning to all. I, Pranali Ganachari, student KSLU's Law School, deem it an honor and privilege to welcome all the dignitaries and students to Honorable Mr. Justice R.G. DESAI Endowment Lecture on Bail, Not Jail, organized by Karnataka State Law University, HUBBALLI. Prayer is not asking. Prayer is putting oneself in the hands of God. So to mark the beginning of this auspicious occasion, with a prayer, I call upon Ms. Pramati Hunsagi, student KSLU's Law School, to invoke the blessings of Lord Almighty.
Gajamukhane siddhidayakane vandipe sharanu Trijagavanditanada deva devane sharan sujanari Vikhnavanu pariharipe sharanu Gajamukhane siddhidayakane vandipe sharanu ಮಂದಮತಿಯನು ಬಿಡಿಸಿ ಚಂದ ಜ್ಞಾನವನಿತು ಮಂದಮತಿಯನು ಬಿಡಿಸಿ ಚಂದ ಜ್ಞಾನವನಿತು ಇಂದಿರೇಶನ ಪಾದ ಹೊಂದಿಪತೆರದಿ ಸುಂದರಾಂಗನೆ ಪದದ್ವಂದ್ವ ಕೆರಗುವೆನಿ ಸುಂದರಾ ಪದದ್ವಂದ್ವ ಕೆರಗುವೆ ಸಂದೇಹ ಮಾಡದಲೆ ಇಂದು ಕರುಣಿಸು ನೀ ಸಂದೇಹ ಮಾಡದಲೆ ಇಂದು ಕರುಣಿಸು ನೀ ಗಜಮುಖನೇ ಸಿದ್ಧಿದಾಯಕನೇ ವಂದಿತೆ ಶರಣು ಹರನತನಯನೆ ಕರುಣಾಕರನೇ ಸುರನರವರಕ ಹರನತನಯನೆ ಕರುಣಾಕರನೇ ಸುರನರವರಕ ಮೊರೆಗಳಾಲಿಸಿ ಕರಗಳನೆ ಪಿಡಿದು ಮೊರೆಯಲಾಲಿಸಿ ಕರಗಳನೆ ಪಿಡಿದು ಪೊರೆಯದಿದ್ದರೆ ಬಿಡೆನು ನೆರೆದೆ ನಿಮ್ಮಡಿಗಳನ್ನು ಪೊರೆಯದಿದ್ದರೆ ಬಿಡೆನು ನೆರೆದೆ ನಿಮ್ಮಡಿಗಳನ್ನು ತ್ವರೆಯಂದದಲ್ಲಿ ನೋಡು ಶರಣಿಂಬೆ ನಿನಗೆ ತ್ವರೆಯಂದದಲ್ಲಿ ನೋಡು ಶರಣಿಂಬೆ ನಿನಗೆ ಗಜಮುಖನೇ ಸಿದ್ಧಿದಾಯಕನೇ ವಂದಿಪೆ ಶರಣು ಸಿದ್ಧಿದಾಯಕನಿ ಹೊತ್ತಿಪೆರೆವೆನು ನಾನು ಸಿದ್ಧಿದಾಯಕನಿ ಹೊತ್ತಿಪೆರೆವೆನು ನಾನು ಅಬ್ಧಿಶಯನನ ಮಹಿಮೆ ಬದ್ಧದಲ್ಲಿ ಬೇಳ್ವ ಅಬ್ಧಿಶಯನನ ಮಹಿಮೆ ಬದ್ಧದಲ್ಲಿ ಬೇಳ್ವ ಶುದ್ಧ ಮತಿಯನೆ ಕೊಟ್ಟು ಧರಿಸಬೇಕೆನ್ನ ಶುದ್ಧ ಮತಿಯನೆ ಕೊಟ್ಟು ಧರಿಸಬೇಕೆನ್ನ ಮಧ್ವವಲ್ಲಭ ಶ್ರೀ ಕೃಷ್ಣ ಗತಿ ಪ್ರಿಯನ ಮಧ್ವವಲ್ಲಭ ಶ್ರೀ ಕೃಷ್ಣ ಗತಿ ಪ್ರಿಯನ ಗಜಮುಖನೇ ಸಿದ್ಧಿದಾಯಕನೇ ವಂದಿಪೆ ಶರಣು ತ್ರಿಜಗವಂದಿತನಾದ ದೇವ ದೇವನೇ ಶರಣು ತ್ರಿಜಗವಂದಿತನಾದ ದೇವ ದೇವನೇ ಶರಣು ತ್ರಿಜಗವಂದಿತನಾದ ದೇವ ದೇವನೇ देवने शरण।
Thank you, Pramati. I now request Professor Dr. G.B. Patil, Registrar Evaluation, Karnataka State Law University, to kindly welcome the dignitaries and invitees. Please, sir.
Good morning to all of you. Madam Rebecca M. John, Senior Advocate, Supreme Court of India, the guest speaker today, Srimati Vijaya M. Khattarki, Guest of Honor, Shri Venkatesh Naik, Principal Law Secretary, Department of Law, Government of Karnataka, Professor Dr. Ratna R. Baramgowda, Honorable Acting Vice Chancellor, Karnataka State Law University, Shri Muhammad Jubair, KAS, Registrar, Karnataka State Law University, Professor C.S. Patil, Senior Professor, Karnataka State Law University, distinguished invitees, learned faculty members of KSLU Law School and other affiliated law colleges, respected members of R.G. DESAI and Khattarki family, esteemed syndicate and academic council members, members of electronic and print media, dear students, ladies and gentlemen. It's a great day for all of us to cherish the memory of late Shri R.G. Desai, former Judge, High Court of Karnataka, Bangalore, in whose remembrance this endowment lecture is arranged. I deem it a privilege to welcome and introduce the dignitaries on this virtual platform. I would like to introduce an illustrious personality, Madam Rebecca M. John, Senior Advocate, Supreme Court of India. Madam enrolled as an advocate with the Bar Council of Delhi in 1988. She has been practicing exclusively on criminal side in Supreme Court of India, High Court of Delhi, and in trial courts for more than 30 years. She is designated as senior advocate in 2013. Madam was the first woman practicing exclusively on the criminal side who was designated as the senior advocate. She has conducted wide range of criminal trials and appeals dealing with offences under Indian Penal Code, special statutes like Unlawful Activities Prevention Act, Prevention of Corruption Act, Prevention of Money Laundering Act, the statute which has made a lot of sound last week after the judgment by the Supreme Court. She has appeared in many famous cases, like, to name a few of them, Jain Hawala case, 1996, 2G Spectrum case, Arusi Talwar murder case, Shrishant IPL match fixing case, Hasimpur massacre case. And because of her hard work and professional expertise, she was appointed as the public prosecutor in Ankit Sharma Saxena murder case. Madam is a founding member of the Internal Complaints Committee of the Delhi High Court, dealing with complaints under the sexual harassment of women at workplace for almost a decade. She is also a member of Delhi High Court Legal Services Committee. With this brief introduction, I am welcoming Madam on behalf of all the statutory officers, staff and students, and on behalf of Khattarki family and Desai family to this function. Welcome you, Madam. It is also my pleasure to welcome Vijaya M. Khattarki. Madam Vijaya was born in Bijapur in a respectable family. Her father, Sri R.G. Desai, was a judge, former judge, High Court of Karnataka during 1978 to 1989. Madam, after graduating in arts from Mount Carmel College, Bangalore, married to Mohan M. Khattarki in 1987, who is a water law expert and a penal advocate for various states in interstate water disputes, and also represented India in International Water Tribunal in various river disputes, and also a senior advocate of Supreme Court of India. Madam, blessed with two sons who have completed their education in a prestigious British universities and well settled in life. Madam has traveled extensively in India and abroad. Madam is also interested in adventurous activities. In 2012, she climbed beyond Mount Base Camp of Mount Everest, nearly 5,164 meters. She is a sports person right from her school days. and she has won so many medals even at the state level badminton tournament. She is a philanthropist and helps the poor and the weaker sections of the society. She is the president of Inner Wheel Club, Delhi and Midwest. With this, I am presenting Madam Vijaya M. Katariki on behalf of all the statutory officers and all the organizers and staff and students. Extend affectionate welcome to you. Welcome to you, Madam.
Thank you.
It is also my pleasure to welcome Sri Mohan M. Katariki, Senior Advocate, Supreme Court of India, for this program. Welcome you, sir. I am happy to welcome the distinguished members of R.G. Desai sir family and Katariki family. Madam Kamalabai Desai, wife of Sri R.G. Desai, former judge, High Court of Karnataka. Srimati Uma Hadagali, Dr. Shaila Basuraj, Arun Desai, Sangappa Desai, Gangabai Desai, Venki Desai, and all the well-wishers of R.G. Desai and Katarki family, welcome you all. I take this opportunity to welcome Madam Ratna R. Baramgaudar, Acting Vice Chancellor, Karnataka State Law University, to this program. Welcome you, Madam.
Thank you, sir.
I also welcome Shri Venkatesh Naik, Principal Law Secretary, Department of Law, Government of Karnataka, to this program. Welcome you, sir.
Thank you, sir.
I take this opportunity to welcome Muhammad Jubair N. KS, Registrar, Karnataka State Law University, Professor C.S. Patil, Senior Professor, Karnataka State Law University. I welcome all the dignitaries who have graced the occasion. I extend a hearty welcome to all the syndicate and academic council members. And also, I welcome all the teaching and non-teaching staff of Karnataka State Law University and other affiliated law colleges, members of the print and electronic media, and all the well-wishers of Katarki and Desai family. And lastly, I welcome the coordinators, Dr. Bhima and Srimati Archana, Assistant Professors, Karnataka State Law University, for their unstinted efforts to make this function a grand success. I welcome once again all of you to this program. Welcome you. Thank you, one and all.
Thank you so much, sir. I now request Dr. Bhima Bai Mulge, Assistant Professor, KSLU's Law School, to kindly read the profile of Honorable Justice R.G. Desai. Please, ma'am.
Thank you, Pranali. Good morning, everyone. It gives me an immense pleasure to present the brief profile of Honorable Mr. Justice R.G. Desai. Honorable Mr. Justice R.G. Desai was born on 1st January 1927 in the prominent family of the erstwhile Bijapur district, then in Bombay Presidency. He graduated from Karnataka College, Dharwad in 1948 and obtained the degree in law from ILS Law College, Pune in 1950. He started his practice as a lawyer in the district court in Bijapur. He was soon recognized for his hard work, intelligence, and all above integrity. In 1958, at an young age, he was appointed as district public prosecutor. He worked tirelessly and conducted the sessions trials with great distinction. His uprightness earned appreciation from one and all in the profession. In 1965, he was selected as the district and session judge. He served at Dharwad, Bellary, Gulbarga, Mangalore, and Bangalore. In 1978, he was appointed as secretary to the government in the Department of Law, Government of Karnataka. In 1979, he was elevated as the judge of the High Court of Karnataka. On retirement in 1989, he served as the chairman of the State Consumer Commission for 3 years. He also functioned as the State Vigilance Commissioner from 1981 to 1984 and was known for his drive against corruption in PWD. He married in 1952 to Mrs. Kamla, daughter of Shankar Gowda Patil of Udupadi, who was well-known landlord. The couples have 2 sons and 4 daughters, who all are well settled. Mr. Arun Desai, who is a practicing lawyer in Bangalore, and Mr. Venkatesh Desai, who is an engineer settled in US. Daughters are Mrs. Pushpa, married to Mr. Prakash Hosmani, a prominent consulting chemical engineer. Mrs. Uma, married to businessman Mr. Chandrakant Halagali. Dr. Shaila, married to orthopedic surgeon Dr. Baswaraj, and Mrs. Vijaya, married to Mr. Mohan Katirki, practicing advocate of the Supreme Court. Honorable Mr. Justice R.G. Desai became one with God on 3rd October 2013. With this brief profile, I conclude. Thank you. Thank you, Pranali.
Thank you, ma'am. I now request Ms. Rebecca Mammen John, Senior Advocate, Supreme Court of India, to kindly deliver the endowment lecture on bail not jail. Please, ma'am.
Thank you very much. I'm extremely grateful to the Karnataka State Law University, its faculty, and its students for inviting me to deliver this lecture. I chose this topic with a particular end in mind. While hearing about Justice Desai, I was happy to note that he served a part of his career as a public prosecutor. So I'm sure that this lecture would have been very meaningful to him as well. The principle bail not jail is a foundational principle to criminal jurisprudence. Unfortunately, over the years, there has been a shift where bail is treated as an exception rather than the rule. Investigating agencies make unnecessary arrests, often in false and motivated cases, even after they have been cautioned by courts to exercise the power as the absolute last resort. These agencies are further enabled by special statutes with restrictive bail powers, as also courts who are now often reluctant to grant bail and instead defer to state authorities. In this context, it is important to revisit some of the elementary principles of bail, which are essential to safeguard personal liberty against illegal coercive state action. The object of bail is to secure the appearance of the accused at trial. The approach of the court in examining applications for bail has therefore necessarily to center around the issue of whether continued incarceration of the accused is imperative towards securing the presence of the accused during trial. The recent judgment passed by the Supreme Court, titled Satinder Kumar Antil versus Central Bureau of Investigation, dated 11th of July 2022, draws from our existing jurisprudence and clarifies the first principles of bail. While noting that statistics indicate that 2/3 of the inmates in Indian prisons are under trial prisoners, the Honorable Supreme Court stressed on the presumption of innocence as a facet of Article 21 of the Constitution of India and reiterated that bail must be the rule and jail the exception. The court stated, and I quote, "Innocence of a person accused of an offense is presumed through a legal fiction, placing the onus on the prosecution to prove the guilt before the court. Thus, it is for that agency to satisfy the court that arrest made was warranted and enlargement on bail is to be denied," unquote. Thus, curtailment of personal liberty during trial must be limited to those cases in which it is absolutely essential to do so. Justice Krishna Iyer, speaking for the bench in State of Rajasthan versus Balchand, 1977 4 SCC, page 308, stated, and I quote, "The basic rule may perhaps be tersely put as bail, not jail, except where there are circumstances suggesting or fleeing from justice or thwarting the course of justice or creating other troubles in the shape of repeating offenses or intimidating witnesses and the like by the petitioner who seeks enlargement on bail from the court," unquote. What is the structure in the CRPC with respect to bailable and non-bailable offenses? The Code of Criminal Procedure 1973 defines offenses into bailable offenses and non-bailable offenses. Section 2A of the code states, and I quote, bailable offenses means an offense which is shown as bailable in the first schedule, or which is made bailable by any other law for the time being in force. And non-bailable offenses means any other offense, unquote. Section 436 of the code states that where a person is arrested for a bailable offense, he shall be released on bail. Section 436 capital A was introduced in 2005 in the CRPC and takes into account the prevailing condition of under trial prisoners. It prescribes that where a person has undergone detention for a period extending up to 1/2 of the maximum period of imprisonment specified for that offense under law, he shall be released by the court on his personal bond with or without sureties. When a person has been arrested in a non-bailable offense, sections 437 to 439 would apply. Section 437 empowers a magistrate to grant bail, but imposes certain conditions which must be satisfied before the court grants bail. For example, a magistrate will ordinarily not release a person on bail if there appear reasonable grounds for believing that he has been guilty of an offense punishable with death or imprisonment for life. Likewise, such person shall not be so released if such offense is a cognizable offense and he has been previously convicted of an offense punishable with death, imprisonment for life, or imprisonment for 7 years or more. Section 439 of the code incorporates the concurrent power of the High Court or the Court of Sessions to grant bail, which are not fettered by the conditions laid down under Section 437. As such, the Court of Sessions or the High Court exercise greater powers than that of the magistrate while granting bail. By and large, where an offense is exclusively triable by a Court of Sessions, the magistrate is circumspect before granting bail, although there are no absolute embargoes on his power to grant bail. Section 438 of the Code of Criminal Procedure lays down the principle of anticipatory or pre-arrest bail. This power too can be exercised concurrently by the Court of Sessions and the High Court, but not by the Magistrates' Court. Personal liberty, protected under Article 21, is at the heart of the Indian Constitution. Coercive measures which allow for personal liberty to be curtailed must be scrutinized and tested rigorously against judicial principles developed to protect the citizen from arbitrary actions of the state. The presumption of innocence acts in favor of the accused person throughout a criminal trial. It is the bedrock of our criminal justice system. It is only at the end of a trial that the court will decide whether the prosecution has been able to prove its case beyond reasonable doubt. The court will then either pronounce the accused guilty of the offense that he has been charged with or acquit him of those charges. As per the Prison Statistics Report 2020, released by the National Crime Records Bureau, Ministry of Home Affairs, under trial inmates account for 76.1% of total prisoners across the country. The report states that the number of under trial prisoners increased by 11.7%, going from 332,916 under trial prisoners in 2019 to 371,848 prisoners in 2020. In Firoz Khan versus State NCT of Delhi, 2020 SCC Online Delhi 1694, the Honorable High Court of Delhi rejected the argument put forward by the state, which had opposed the bail on the ground that given the nature of the crime, the grant of bail at an early stage may send an adverse message to society. The court observed, and I quote, "Prison is primarily for punishing convicts, not for detaining under trials in order to send any message to society. The remit of the court is to dispense justice in accordance with law, not to send messages to society. It is this sentiment whereby the state demands that under trials be kept in prison inordinately without any purpose that leads to overcrowding of jails and leaves under trials with the inevitable impression that they are being punished even before trial and therefore being treated unfairly by the system. If at the end of a protracted trial, the prosecution is unable to bring home guilt, the state cannot give back to the accused the years of valuable life lost in prison. On the other hand, an accused would of course be made to undergo his sentence after it has been awarded post-trial, unquote. What are the consequences of pre-trial detention? I can think of three principal consequences. One, pre-trial detention presumes an accused person to be prima facie guilty of the crime and has the effect of throwing out the time-honored principle of innocent unless proven guilty. Pre-trial detention is punitive in nature. It keeps a person in custody at the pre-trial stage without any formal determination of his guilt. Pre-trial detention prevents an accused from preparing his defense as a free agent. In Motiram versus State of Madhya Pradesh, 1978 4 SEC page 47, the Supreme Court observed that, and I quote, "The consequences of pre-trial detention are grave. Defendants presumed innocent are subjected to psychological and physical deprivations of jail life, usually under more onerous conditions than are imposed on convicts. The jail defendant loses his job, if he has one, and is prevented from contributing to the preparation of his defense. Equally important, the burden of his detention frequently falls heavily on the innocent members of his family," unquote. In Babu Singh versus State of Uttar Pradesh, 1978 1 SEC page 579, it was stated, "We must weigh the contrary factors to answer the test of reasonableness subject to the need for securing the presence of the bail applicant. It makes sense to assume that a man on bail has a better chance to prepare or present his case than one remanded in custody. And if public justice is to be promoted, mechanical detention should be demoted." In Navendu Babbar versus State, the Delhi High Court, citing Motiram and Babu Singh, held that the consequences of pre-trial detention are grave, and keeping an under trial in jail seriously jeopardizes the preparation of his defense. Further detention of the applicant in custody would necessarily impact his right to defend himself during trial, inasmuch as he will be denied effective consultation with his lawyers, collection of evidence in his defense, and other footwork that he would require to defend himself actively and effectively. This would clearly be a denial of a right to fair trial, which is guaranteed under Article 21 of the Constitution of India. In a recently decided case of Mohammad Zubair versus State of NCT of Delhi and others, Writ Petition Criminal 279 of 2022, the Supreme Court, while granting bail to Mohammad Zubair, a co-founder of Alt News, a fact-checking portal which conducts its activities under Pravda Media Foundation, had occasion to observe that, and I quote, "Police officers are vested with the power to arrest individuals at various stages of criminal justice process, including during the course of investigation. However, this power is not unbridled. In terms of sections 41(1)(b)(2) of the CRPC, the police officer in question must be satisfied that such arrest is necessary to prevent the person sought to be arrested from committing any further offense, for proper investigation of the case, to prevent the arrestee from tampering with or destroying evidence, to prevent them from influencing or intimidating potential witnesses, or when it is not possible, to ensure their presence in court without arresting them. Arrest is not meant to be and must not be used as a punitive tool, because it results in one of the gravest possible consequences emanating from criminal law, the loss of personal liberty. Individuals must not be punished solely on the basis of allegations and without a fair trial. When the power to arrest is exercised without application of mind and without due regard to the law, it amounts to an abuse of power. Criminal law and its processes ought not to be instrumentalized as a tool of harassment. The police, therefore, should avoid arresting a person and sending them to jail if it is possible for the investigation to be concluded without an arrest. Only in cases of utmost necessity, or depending upon the seriousness of the crime, should a person be arrested. The liberty of a citizen is of paramount importance and a constitutional guarantee and cannot be incised. Therefore, the police or investigating agency should not remain under the impression that every cognizable and non-bailable offense, they would invariably arrest the offender. Power to arrest is altogether different from the need to arrest. The existence of the power to arrest vested with investigating agencies is different from the justification of its exercise. Arrest brings humiliation, curtails freedom, and casts scars forever. A balance must therefore be maintained between individual liberty and societal order. Arrest shouldn't be made purely on the basis of the offense being a non-cognizable and non-bailable offense. The facility which Section 438 of the Code of Criminal Procedure affords is generally referred to as anticipatory bail, an expression used for the first time in the 41st Law Commission report. Neither the section nor its marginal notes describe it so. But the expression anticipatory bail is a convenient way of conveying that it's possible for bail in anticipation of arrest. In the Constitution Bench judgment of the Supreme Court titled Gurbakh Singh Sibia versus State of Punjab, 1980, Volume 2, SCC, page 565, the Supreme Court defined anticipatory bail as, and I quote, the distinction between an ordinary order of bail and an order of anticipatory bail is that whereas the former is granted after arrest and therefore means release from the custody of the police, the latter is granted in anticipation of arrest and is therefore effective at the very moment of arrest. Police custody is an inevitable concomitant of arrest for non-bailable offenses. An order of anticipatory bail constitutes, so to say, an insurance against police custody following upon arrest for offense or offenses in respect of which the order is issued. In other words, unlike a post-arrest order of bail, it is the pre-arrest legal process which directs that if a person in whose favor it is issued is thereafter arrested on the accusation in respect of which the direction is issued, he shall be released on bail. If an application, unquote, if an application for anticipatory bail is made to the High Court or that of the Court of Sessions, it must apply its own mind to the question and decide whether a case has been made out for granting such relief. The filing of a first information report is not a condition precedent to the exercise of a power under 438. The imminence of a likely arrest founded on a reasonable belief can be shown to exist even if an FIR is not yet filed. Anticipatory bail can be granted even after an FIR is filed, so long as the applicant has not been arrested. After arrest, the accused must seek his remedy under Section 437 or Section 439 of the Code if he wants to be released on bail in respect of the offense or offenses for which he is arrested. What are the possible grounds for denial of bail when investigation is pending? Seriousness of the offense, the possibility of tampering with evidence, the derailing of the course of investigation or trial are some of the reasons cited for denial of bail. Non-cooperation by the accused, often cited by the prosecution as a ground to seek custody, is actually not a ground for denial of bail. The accused has a right of silence under Article 23 of the Constitution. The accused also has the right to bring out his defense during trial. There is a reason why an accused is not required to furnish any written statement on oath, unlike in civil cases where defendants are bound to do the same. The accused cannot be kept in custody till the impasse between him and the IO with respect to cooperation or non-cooperation is resolved. In Navendra Babu versus State, the Delhi High Court judgment, which I had earlier mentioned, the Honorable High Court of Delhi held that a criminal investigation is not a metaphorical fishing rod handed to an investigating agency to indulge its penchant for fishing around for evidence at its own leisure and in the fullness of time. Investigation has to be a time-limited process to be conducted strictly within the structure and framework of the Criminal Procedure Code. It may be worthwhile here to trace the journey of an arrested accused and the protections and remedies given by law in terms of the constitutional protections guaranteed under Articles 21 and 22 and the Code of Criminal Procedure. Section 57 of the CRPC provides that any person arrested must necessarily be produced before a magistrate within 24 hours. This was considered such an important safeguard that the framers of the Constitution deemed it essential to incorporate it as a fundamental right in the Constitution in terms of Article 22(2), even though it is a statutory right available to an accused under Section 57 of the Code of Criminal Procedure. Remand proceedings begin after the suspected person or accused is produced before a magistrate. Remand proceedings at the stage of investigation are related to keeping persons in custody prior to the commencement of trial and are governed by Sections 167 of the Code of Criminal Procedure. Section 167 permits a magistrate to remand an accused in tranches of 15 days at a time for a total of 60 or 90 days, depending on the punishment of the offense for which the individual is charged. In the landmark judgment passed by the Supreme Court, CBI versus Anupam J. Kulkarni, 1992, Volume 3, SCC, page 141, it was held, and I quote, "The detention in police custody is generally disfavored in law. The scheme of Section 167 is obvious and is intended to protect the accused from the methods which may be adopted by some overzealous and unscrupulous police officers. Article 22, subclause 2 of the Constitution of India and Section 57 of the CRPC give a mandate that every person who is arrested and detained in police custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey. And no such person shall be detained in the custody beyond the set period without the authority of the magistrate." These provisions clearly manifest the intention of the law in this regard, and therefore it is the magistrate who has to judicially scrutinize circumstances, and if satisfied, can order the detention of the accused in police custody. Section 167(3) requires that the magistrate should give reasons for authorizing the detention in the custody of the police. It can thus be seen that the whole scheme underlying the section is intended to limit the period of police custody. However, taking into account the difficulties that may arise in completion of investigation of cases of serious nature, the legislature added the proviso providing for further detention of the accused for a period of 90 days. But in clear terms, it is mentioned in the proviso that such detention could only be in judicial custody. During this period, the police are expected to complete the investigation even in serious cases. Likewise, within the period of 60 days, they are expected to complete investigation in respect of other offenses. The legislature, however, disfavored even the prolonged judicial custody during investigation. In Hitendra Vishnu Thakur versus State of Maharashtra, 1994, Volume 4, SCC, page 602, the Supreme Court held that the legal position has been ably stated in Aslam Babalal Desai versus State of Maharashtra, where speaking for the majority, Justice Ahmadi referred with approval to the law laid down in Rajnikant Jeevanlal Patel versus Intelligence Officer NCB New Delhi, wherein it was held that the right to bail under Section 167(2) proviso is absolute. It is a legislative command and not the court's discretion. If the investigating agency fails to file a charge sheet before the expiry of 90 or 60 days, as the case may be, an accused is entitled to be released on bail. This is known as statutory bail. And this is an absolute right vested in an accused person. If the investigating agency does not complete investigation within 60 or 90 days, an accused is entitled to default bail or statutory bail, as it is commonly known in law. What is the law with respect to bails granted after the charge sheet is filed? As I have repeatedly stated, the object of bail is to secure the appearance of the accused at trial and is not meant to be punitive in nature. After investigation is completed, the presence of the accused in custody may not be necessary any further. In Sanjay Chandra versus CBI 2012, Volume 1, SEC page 40, this is with respect to the 2G spectrum case, the Supreme Court held that as the investigation was complete, the accused persons were no longer required for purposes of participating in the investigation, and all that was required of them was to face their trial. Therefore, bail was in order, notwithstanding the seriousness of the offense. In Satyendra Kumar Antil versus Central Bureau of Investigation, a recent case decided on 11/7/2022, the Supreme Court further clarified that if the investigating agency has not arrested the accused during investigation, the court, on submission of the charge sheet and appearance of the accused, must grant bail unless the offense is punishable by a term of imprisonment beyond 7 years. However, there is a different jurisprudence with respect to grant of bail pertaining to special statutes. Contrast the jurisprudence referred to earlier by me with the jurisprudence developed by our courts with respect to grant or refusal of bail under a basket of special legislations. Over the years, several special statutes have been enacted for a wide variety of offenses, including exceptions to general criminal law. For instance, the now repealed Terrorist and Disruptive Activities Prevention Act 1987, the Prevention of Terrorism Act POTA, again repealed, the Unlawful Activities Prevention Act UAPA, the Prevention of Money Laundering Act 2002 PMLA, and the Narcotics, Drugs and Psychotropic Substances Act NDPS Act, to name a few. For the purpose of this discussion, I will compare some of these bail provisions. Under Section 37 of the NDPS Act, twin conditions have to be satisfied before bail is granted. The court must be satisfied that there are reasonable grounds for believing that the accused is not guilty of the offense and is not likely to commit any offense in future. Under Sections 21(4) of MACOCA, or the Maharashtra Control of Organized Crimes Act, the language used in Section 37 of the NDPS Act is repeated and the same conditions are imposed. Under Section 45 of PMLA, the twin conditions require, once again, for the court to be satisfied that the accused is not guilty of the offense and is not likely to commit any offense in future. Likewise, under the Unlawful Activities Prevention Act, other conditions need to be satisfied. The court needs to be satisfied that the accused is prima facie not guilty of the offense before it grants bail. The Supreme Court in Nikesh Tarachand Shah, while dealing with Section 45 of PMLA, held that we must not forget that Section 45 is a drastic provision which turns on its head the presumption of innocence, which is fundamental to a person accused of an offense. Before application of a section which makes drastic inroads into the fundamental right of personal liberty guaranteed by Article 21 of the Constitution, we must be doubly sure that such provisions furthers a compelling state interest for tackling serious crime. In the absence of any compelling state interest, the indiscriminate application of the provisions of Section 45 will violate Article 21 of the Constitution. Some of this has been overturned in the recent PMLA judgment, Vijay Madan Lal Chaudhary, where the Supreme Court held that the twin conditions post the 2018 amendments of the 2002 Act stand revived as the legislature has cured the defect that led to the original twin conditions to be struck down in Nikesh Tarachand Shah. Section 43D5 of the UAPA is different in language. It uses, while considering the issue of bail, it does not expect the court to be satisfied that there are reasonable grounds for believing that an accused is not guilty of an offense and is not likely to commit any offense in future. Rather, it states that the court, upon examining case diaries of the charge sheet, must not grant bail if there are reasonable grounds for believing that the accusation against such person is prima facie true. The provisions governing bail in the Code of Criminal Procedure, namely 437 and 439, begin with the phrase, "Court may direct that any person accused of an offense and in custody be released on bail." These are enabling provisions. However, provisions such as Section 43D5 and Section 45 of the PMLA, as well as UAPA, create an embargo on the grant of bail. It begins with the phrase, "Notwithstanding anything contained in the code, no person accused of an offense punishable under chapters 4 and 6 of the Act shall be, if in custody, released on bail." The conditions for grant of bail with respect to NDPS Act, MACOCA, PMLA, UAPA demand that the court return a finding that the accused is not guilty of the crime and is not likely to commit an offense in future. In UAPA, the allegations against the accused must be prima facie true, and if they are prima facie true, the court shall not grant bail. This, I submit, goes counter to the jurisprudence of bail, which India has otherwise followed. In a judgment passed by the Supreme Court titled Ranjit Singh versus State of Maharashtra, 2005, Volume 5, SCC 294, the Supreme Court, while examining the conditions under MACOCA for grant or refusal of bail, said that the court must arrive at a positive finding that the accused is not guilty of an offense, and this is a very difficult thing for a court to do. The Supreme Court recognized the absurdity of the twin conditions, also for the reason that having granted bail to an accused person on the ground that he's not guilty of an offense would be an impossibility. It would result in an impossibility later on for the prosecution to prove its case. There are other judgments passed by the Supreme Court, including judgments in UAPA, Zarur Ahmad Shah Vatali, where once again the power of bail has been restricted by the Supreme Court under UAPA. I submit that it was never the intention of Parliament to create a completely insurmountable barrier for grant of bail. Interestingly, this is also recognized in the judgment of Vatali, as it states that the degree of satisfaction is lighter under UAPA than under some other special statutes. In the Delhi riots case, on last count, the prosecution is seeking to rely on 740 witnesses in charge sheets filed with respect to FIR number 59 of 2020, Police Station Special Cell, in which several members of civil society, students, and activists are charged with offenses under UAPA. Even a dedicated court that has been assigned for purposes of this case has not yet framed charges against the accused persons. Most of the accused persons were arrested sometime in March, April 2020, and at this stage, it will take several years before the trial will be concluded, and they will remain in custody without grant of bail. The situation in the Bhima Koregaon case, as well as other cases, is also the same. The first arrests in the case were made in June 2018, and as of today, most of them continue to be in custody. In a case titled State versus Tariq Ahmed Dar and others relating to a 2005 Delhi serial bomb blast, I had appeared for a student of Kashmir University, Mohammad Rafiq Shah. Rafiq was attributed the role of planting a bomb in a moving bus. Even during his interrogation and custody, he had consistently and repeatedly taken the defense that he was not present in Delhi on the day of the blast and was in fact attending his classes in Kashmir University. He pleaded with his interrogators to have the record collected from the university to verify his claim. During the trial, special cell officers conceded that they were aware of his claim, but they were not able to verify whether his claim was truthful or not, because the registrar of the Kashmir University could not be contacted by them. They denied receipt of any information from the university in this regard. It was then left to Rafiq to produce witnesses in his defense from the university, who produced the original record of that time to show that he was a bona fide student, and the attendance registers marked his presence in class on the day of the incident. Professors who took the classes Rafiq attended on the day of the incident also deposed in favor of Rafiq. The court, in its final judgment, accepted Rafiq's plea of alibi and acquitted him of all charges. This happened 12 years after he was arrested, and during this entire period, he remained in custody. I may add that the case of the prosecution rested on the evidence of a singular witness who was thoroughly discredited in cross-examination. In the final judgment, the trial court also came to the conclusion that the witness's testimony was fabricated. However, Rafiq could not succeed in any of his bail applications he moved after the testimony of the witness was recorded. And this highlights the mindless weightage given by courts to the label attached to a case. The labeling of these cases as serious by the prosecution is a tool to oppose bail. There seems to be no parallel urgency on the part of the prosecution to produce serious evidence in court, test its veracity, conclude trial within a foreseeable time frame. The idea, therefore, is to incarcerate targeted individuals for as long as possible, denying bail throughout on the ground that there is prima facie material against them, but not produce that material because that would bust their claim. Moving on, there is also now a growing tendency to arrest accused persons in speech cases. In the last few years, we have seen the increasing use of the criminal justice system and the machinery of investigating agencies to try and stifle voices of dissent by registering FIRs against those critical voices that choose to speak. Recently, multiple FIRs were registered against journalist Mohammed Zubair of Alt News for a tweet he put out 4 years ago in 2018. The Supreme Court, while granting bail, stated, as evident from the facts narrated above, the machinery of the criminal justice has been relentlessly employed against the petitioner. These are the words of the Supreme Court, not my words. Despite the fact that the same tweets allegedly gave rise to similar offenses in diverse FIRs mentioned above, the petitioner was subjected to multiple investigations across the country. Consequently, he would be required to hire multiple advocates across districts, file multiple applications for bail, travel to multiple districts spanning 2 states for the purposes of investigation, and defend himself before multiple courts, all with respect to substantially the same cause of action. Resultantly, he is trapped in a vicious circle. Excuse me. Of the criminal process, where the process has itself become the punishment. In Arnab Goswami's case, the court said the doors of this court cannot be closed to a citizen who is able to establish prima facie that the instrumentality of the state is being weaponized for using the force of criminal law. Our courts must ensure that they continue to remain the first line of defense against the deprivation of liberty of citizens. Deprivation of liberty, even for a single day, is one day too many. We must always be mindful of the deeper systemic implications of our decisions. I chose to speak today on the subject of bail, not jail, as the issue of bail is one of liberty, justice, public safety, all of which insist that a developed jurisprudence of bail is integral to a socially sensitized judicial process. The exercise of state power to incarcerate citizens must necessarily be limited and curbed in any democratic society. Bail is an important right that prevents incarceration being used as a punishment even against those who have not been held guilty of having committed any crime. In Guddikanta Narasimhallu and others versus public prosecutor, this is the judgment of which is reported in AIR 1978, Supreme Court 429, where Justice Krishna Iyer first coined this phrase. And I will quote from that judgment: bail or jail at the pre-trial or post-trial conviction belongs to the blurred area of the criminal justice system and largely hinges on the hunch of the bench, otherwise called judicial discretion. Personal liberty deprived when bail is refused is too precious a value of our constitutional system, recognized under Article 21. The crucial power to negate it is a great trust exercisable not casually but judicially. with lively concern for the cost of the individual and the community. After all, personal liberty of an accused is fundamental, suffering lawful eclipse only in terms of procedure established by law. The last 4 words of Article 21 are the life of that human right. The doctrine of police power constitutionally validates punitive processes for the maintenance of public order, security of the state, national integrity, and the interests of public generally. Even so, having regard to the solemn issue involved, deprivation of personal freedom, ephemeral or enduring, must be founded on the most serious considerations relevant to the welfare and objectives of society specified in the Constitution. The considerable public expense in keeping in custody when no danger of disappearance or disturbance can arise is not a negligible consideration. Equally important is the deplorable condition, verging on the inhuman, of our sub-jails, that the unrewarding cruelty and the expensive custody of avoidable incarceration makes refusal of bail unreasonable and a policy favoring release justly sensible, unquote. Our courts must ensure that they continue to remain the first line of defense against the deprivation of liberty of citizens. Liberty across human eras is as tenuous as can be. Liberty survives on account of vigilance of its citizens, on the cacophony of the media, in the dusty corridors of courts, alive to the rule of law and not by law. Denial of liberty, even for a day, is one day too many. Thank you.
Thank you so much, ma'am, for gracing the occasion and enriching us by your scholarly knowledge. I now request Srimati Vijaya M. Katarki, guest of honor, to kindly address us. Please, ma'am.
Good morning to all of you. Senior Advocate Rebecca John, Vice Chancellor Ratna Paramgowdar, faculty members, students, lawyers, honorable judges, ladies and gentlemen. After an erudite speech by an eminent senior advocate, Rebecca John, there is really nothing for me to add. She has forcefully advocated bail for the accused. We all see many innocent people languishing in jail for years without a bail. Their liberty to live freely is denied just because there is some suspicion. But we all know suspicion is no proof of crime. My father, Justice R.G. DESAI, was a criminal lawyer, prosecutor, and High Court judge. He earned reputation as a bold prosecutor, since he used to agree to all deserving cases. I'm happy to say Rebecca's ardent support for bail is a tribute to his memory. I'm sure you all have enjoyed the lecture. My best wishes to students, and I'm thankful to faculty members and Rebecca for sparing her valuable time in delivering this endowment lecture. Thank you.
Thank you so much, ma'am, for your kind words. I now request Professor Dr. Ratna R. Paramgowdar, Honorable Vice Chancellor, Acting, Karnataka State Law University, to kindly deliver the presidential address. Please, ma'am.
Thank you, Pranali. My greetings to all. Esteemed Ms. Rebecca Mammen John, Senior Advocate, Supreme Court of India, Srimati Vijaya Katarki, Guest of Honor, Shri Venkatesh Nayak, Principal Secretary, Law Department, Mr. Mohammad Zubair, Registrar of the University, Professor G.B. Patil, Registrar Evaluation, Shri Mohan Katarki, Senior Advocate, Supreme Court, family members of Honorable Mr. Justice R.G. DESAI, invitees, esteemed principals from our affiliated law colleges, esteemed faculty members, and dear students. Endowment lectures provide an opportunity to faculty and students to meet and learn from distinguished scholars. Today, we are extremely happy to organize Honorable Mr. Justice R.G. DESAI Endowment Lecture on the topic Bail, Not Jail by renowned criminal law advocate Ms. Rebecca John. What is liberty and is it the same for all? Philosophers, lawyers, academicians, lawmakers, and several others over millennia have tried to answer this question. And recently, the Supreme Court of India also tried to answer this question by making an observation that liberty, as embedded in the law, has to be preserved and protected. The Supreme Court has directed the center to consider framing new legislation on bail to streamline the release of accused in the criminal cases, noting that the Code of Criminal Procedure as it exists today is a continuation of the pre-independence era. There is a pressing need to reform the laws on bail, as jails in the country are flooded with under trial prisoners, and the majority of them may not even be required to be arrested despite registration of a cognizable offense against them. The Supreme Court has observed that arrest is a draconian measure resulting in curtailment of liberty, and thus it is to be used sparingly. In a democracy, there can never be an impression that it is a police state, as both are conceptually opposite to each other. In today's endowment lecture, Senior Advocate Ms. Rebecca John has referred to series of Supreme Court cases and has emphasized that unless there are some cogent reasons for custodial interrogation and sustained detention at a pre-trial stage, detaining an individual and encroaching upon right to liberty of a person is considered to be punitive and against the principles of natural justice. We also need to reflect on the recent trends of media in influencing human minds. This has been a serious roadblock in achieving the ends of justice. Because of TRPs, news channels conduct media trials along with judicial trials, and this will somehow affect the minds of the judges also. Now, it is the need of the time that the judiciary interprets the bail laws in a very systematic and effective manner so that no government can infringe the right of personal liberty of any individuals. On behalf of Karnataka State Law University, I heartily thank Ms. Rebecca John, Senior Advocate, Supreme Court of India, for accepting our invitation and for delivering a highly insightful and scholarly lecture. Thank you, ma'am. On behalf of university, I also thank Srimati Vijaya Katarki, guest of honor, for her valuable address. Thank you one and all.
Thank you so much, ma'am. I now request Dr. Rangaswamy D, Assistant Professor, KSLU's Law School, to propose the vote of thanks. Please, sir.
Good morning to one and all present over here. Most respected dignitaries of this virtual platform, participants, ladies and gentlemen. It is indeed a great pleasure for me to place on record our sincere gratitude to all who regarded regular annual event of Karnataka State Law Endowment Lecture. At the outset, I would like to place on record our deepest gratitude to the resource person of the today's endowment lecture, Ms. Rebecca M. John, Senior Advocate, Supreme Court of India, for accepting our invitation and delivering such a mind-bending lecture on the topic bail, not jail. Madam, indeed, it was an impressive speech in sketching our young minds for better criminal justice system in the days to come. On behalf of Karnataka State Law University, on behalf of all the faculty members, our heartfelt thanks to you, madam. Karnataka State Law University is generously supported and enormously backed by varied endowment lectures. Honorable Mr. Justice R.G. DESAI Endowment Lecture is one amongst them, dedicated to the university by Shri Mohan V. Katarki and Srimati S. Vijaya Katarki to decorate legal education of the university with predominant scholars. On behalf of Karnataka State Law University and all the participants, I would like to convey our sincere thanks to Shri Mohan Katarki and Srimati Vijaya Katarki for their big-hearted support in constituting this endowment lecture and being part of this program today. Thank you, sir. Thank you, madam. Our honest thanks to family members of Justice R.G. Desai for gracing the occasion and joining their hands for grand success of this lecture. Thank you all. I would like to thank our young and enthusiastic acting Vice Chancellor, Professor Dr. Ratna R. Brahmagaudar. The role played by Madam in fine-tuning this program is immense. Madam, on behalf of the university, on behalf of all the participants, I express our deepest gratitude to you, Madam.
Thank you.
I would like to thank Sri Venkatesh Nayak T, Principal Secretary to Government, Department of Law, Government of Karnataka, being part of this program. Thank you, sir. I sincerely thank Muhammad Zubair, Karnataka Administrative Service, Registrar, Karnataka State Law University, for his genius support in actualizing this program. Thank you, sir.
Thank you.
Our biggest thanks to Professor Dr. G.B. Patil, Registrar, Karnataka State Law University, and Professor C.S. Patil, Professor of Law, Karnataka State Law University, for gracing this occasion. Thank you, sirs.
Thank you.
We are intensively indebted to all the syndicate and academic council members of the university, principals of various affiliated law colleges, teaching staff, advocates, for their unconditional support extended for this program. Thank you all. The coordinator of the event, Dr. Bhima Bai S. Mulge and Srimati Archana, have rendered their labor and skills in a greater scale for the success of this program. Our sincere thanks to them also. Thank you, madam. I will be failing in my duty if I don't mention the active role played by our faculty members, staff, student of KSLU's Law School for the success of this program. I extremely thank you all for your support. Thank you all. So once again, our sincere thanks to you all. Thank you.
Thank you.
Thank you, madam.
Thank you. Thank you very much.
Thank you so much.
It was a pleasure appearing. Thank you so much.
Madam, it was really a very enlightening address. Once again, I thank you on behalf of University, ma'am. Thank you so much.
Thank you very much. Thank you very much for calling me, and it was a privilege.